Over the last 15 years, there have been significant and fast-changing progress in the recognition of same-sex relationships. It began with domestic partnerships, which evolved into civil unions, and then finally fully recognized marriage for same-sex couples. Because of the hodgepodge nature of different states and their enactment of different statuses pertaining to same-sex couples, it is sometimes difficult for couples to fully understand their rights and obligations when it comes to dissolution or divorce, depending on their status. In New Jersey alone, same-sex couples, depending on when they first entered into a legally recognized relationship status, could have entered into a domestic partnership, a civil union, or a marriage over those years. Each of the statuses conferred different rights and obligations to the parties. Domestic partnerships were first available to same-sex couples in New Jersey in 2003. These partnerships provide limited health care, inheritance, and other property rights. It's important to understand that parties in a domestic partnership are not afforded the same broad litany of rights and obligations afforded to married couples. For example, at the time of the termination of domestic partnership, there is no right to alimony or support, no right to equitable distribution of assets, and no right to pension benefits, unless the pension voluntarily created such a right. In 2007, New Jersey created civil unions, which provide almost all rights under New Jersey law as are afforded to opposite-sex couples in a marriage. Civil unions created the same rights under state law at the time of dissolution as those afforded to married couples, including the right to alimony and support and equitable distribution of assets. However, because the federal government does not recognize civil unions, federal tax benefits, Social Security benefits, and estate benefits are not available to couples in a civil union. In 2013, New Jersey began to recognize marriages for same-sex couples. Shortly thereafter, in 2015, the United States Supreme Court recognized the rights of same-sex couples to enter into marriages throughout the United States. So same-sex couples are now entitled to recognition under New Jersey law as well as other states in the United States. At the time of the divorce, same-sex couples have the same rights and obligations as opposite-sex couples, including both federal and state benefits. Every situation is unique, and over the years, many same-sex couples have entered into multiple statuses in New Jersey and elsewhere. It is important to understand the implications of each legally recognized status and how dissolution of each status affects you and your family. If you are unclear of your particular situation, or if you just want to more comfortably understand your rights, it is in your best interest to consult with a family law attorney who has experience dealing with same-sex relationships.
For more information, contact the law offices of Einhorn Barbarito